Okay, so here we are, Dan Ray and Brendan Beery. We've been talking about what's going on out there, and it seems like it's getting kind of crazy. Dan, what do you think?
It's getting scarier by the day, quite frankly. I read news piece after news piece every single day about some poor security guard just trying to do his or her job. And we've had a couple out of Flint, Michigan, which is about a half hour north of me here. One security guard got shot in the head because he told the woman she needed to wear a mask. Another security guard, or another, I think it was a cashier, told a patron that he needed to wear a mask, and in response, the patron wiped his nose on her shirt.
Yeah, real class act.
Yeah, and so it's to the point, frankly, where the government's not going to have any choice but to act.
And there is some enforcement, it looks like, going on. I'm seeing more of that in the news as well, where I know in Sacramento a few days ago, 32 people were arrested for demonstrating, first of all, without a permit, which also leads into the thing we're going to talk about today, right? They're demonstrating without a permit. They were disobeying lawful orders, right, to separate and disperse. So yeah, I mean, as we see more of these social distancing and mask wearing edicts kind of being enforced, it seems like there's a backlash to that among people, who it seems like they just wait for some, they feel aggrieved all the time, right? So they're just waiting for something to adopt as their new cause.
They're looking for an excuse to misbehave, I would argue, and they're doing it now because they know that the government's got its hands full with other things. The government's busy trying to save lives and protect health. And so we can't go after everybody who decides that they want to act like a 9-year-old with daddy issues. So here we find ourselves. And yeah, you're right. The people who are getting busted for violating social distancing and mask wearing regulations are going to come back and say, well, it's my right to speak and I can gather with people who agree with me. So it's going to be a First Amendment issue sooner or later, and here we are.
That's why we wanted to do this, because they're going to come back with, first, like as you just said, First Amendment is my First Amendment right. You can't mess with me. I have a right to be here, right? I have a right to be standing next to people demonstrating, right, without a mask on, not standing 6 feet apart. So we got to talk about what legal principles, because when somebody makes that argument, I guess I'll just throw this out there, what's the general response to that?
First of all, excuse me, the First Amendment says Congress shall make no law. Well, no law doesn't really mean no law. When it comes to speech regulation, the sort of fault line, the First Amendment speech fault line, or dividing line, if you will, is something that we call content-based regulation. As the name suggests, that means the government is trying to regulate speech because it doesn't like the content. It doesn't like the message, to put it even more bluntly. So the government tries to come up with different ways to regulate that message. Well, if the speaker can show that it is in fact a content regulation, then the burden on the government is much higher. We find ourselves in a circumstance where the government has to satisfy the strict scrutiny standard. And we talked about that a few days ago. The strict scrutiny standard is a relatively high burden for the government to bear. But under circumstances like these, the government should be able to carry that burden. On the other hand, if the speaker can't prove that this is a content-based regulation, then the government has much more leeway to regulate the speech. The government can regulate the speech by saying, look, we're not trying to go after the message here. We don't care what your message is. We're trying to regulate some non-content aspect of the speech. So what might that non-content aspect of the speech entail? It entails things like the time that the speech happens, the place where the speech takes place, or the manner in which the speaker expresses the message. The so-called time, place, or manner regulation is a well-known subset of speech regulation, and that's part of what we're going to talk about this afternoon.
Yeah, and if we didn't have time, place, manner regulations, and that's what we want people to come away with, right? There's this thing in First Amendment law called a reasonable time, place, manner restriction. If it wasn't for that, you and I, right? I have no problem. Somebody wants to tell me that they hate Hillary Clinton or they hate, pick your favorite person to hate, right? Somebody wants to express that opinion. Who cares? That's their opinion. But if they're doing that at 3 o'clock in the morning on the sidewalk outside my house in a residential neighborhood, right, with a bullhorn, we got a problem.
And that's a good example, by the way, the one that you just gave. In that circumstance, the government's going to show up in court and say, Judge, look, we don't care that the message is we can't stand the governor or we hate social distancing. The government is going to say, we're trying to maintain peace and quiet for homeowners who don't feel compelled to express that message at 3 o'clock in the morning, right? That has nothing to do with the content of the message and everything to do with neighborhood peace and tranquility, right?
As a matter of fact, it's interesting you mentioned that. The governor of California, Gavin Newsom, I think I'm getting that right.
Right.
He's doing I thought he issued a statement that that reflected well on him. He said in response to the demonstrations, he was very accommodating in terms of, but here's Lainey, she had to get in the picture.
The star of the show.
Yeah, oh yeah. But he was very accommodating, and he said, it's absolutely your right to oppose me, to oppose any of the restrictions that I've ordered. Please just do it with a mask on and standing 6 feet apart. That's it.
There you go. How difficult is that? And quite frankly, I am absolutely confident that if called upon to defend her regulations in court, Governor Whitmer would say precisely the same thing. I don't care what your message is. You don't like me? That's great. You've got lots and lots of different ways you can express that message. The bottom line is, she would argue, we are doing this. We're requiring masks, we're requiring social distancing in order to, and this should sound familiar to people who have been following the video, we are doing this to save lives and to preserve health. Anytime you hear the government say that, we're acting to save lives and protect health, first thing you should think, oh, the government's trying to argue that it's got a compelling interest in case it needs to pull that tool out of its back pocket.
I'm hearing like a two-layered argument from the government legally when somebody raises a First Amendment defense. Number one is time, place, manner, and let's run through the elements here in a minute. But under time, place, manner, right? Number one, they're going to argue it's a reasonable time, place, manner restriction. That's all it is. And the linchpin of that is we're not concerned with the message. We don't care. It's a content neutral, right, regulation. But even if it's a content-based regulation, right, that just kicks you into strict scrutiny, which the government may be able to pass anyway because they're trying to save lives, right, using the only means available, which is to keep people apart.
That's precisely the argument that we're talking about here, and you kind of are honing in again on what I think is a critical point, and it's one that I think our viewers should sort of keep in mind, and that is, if you are the speaker in a First Amendment case, you are always going to argue that the government is regulating based on the content of your speech, right? Because you want to force the government into strict scrutiny. As the speaker, that's your best chance to win. By contrast, if you are arguing on behalf of the government, you're going to argue precisely the opposite.
So let's run through the elements of a reasonable time, place, manner restriction. Number one would be content neutrality. So we just hit that. If you get past that, the government needs a significant interest, right, to impose a time, place, manner restriction. But courts are pretty, I don't know, I would say pretty loose about that. And in a case like this, there's no question about the interest, right? I mean, the interest is
no question.
Then we have what you explained real well the last time we talked, which is the means part of it, right? Whether you're applying time, place, manner, or strict scrutiny, there has to be some kind of a relationship between the means, right, and what you're trying to achieve. And again, there's not going to be a problem with that because there's not a scientist, there's not a a reputable scientist in the country who's going to take issue with keeping people 6 feet apart so that an airborne virus cannot spread.
That's what I think most judges and courts would look at and call a de minimis burden, right?
But the final part of the time, place, matter test, I think of these as elements, right? You have to have content neutral, significant interest. The means have to more or less match up with the interest. And then you have the final element of time, place, matter restriction is ample alternatives, right? The government has to leave you ample alternatives. So what do you do when these folks say, if you disperse me from the Capitol steps and I can't stand next to my buddies with weapons and camouflage on, I don't have a chance to get my message out?
Well, that, again, under the circumstances, I think that's a pretty easy one for the government to answer. For starters, we're not telling you that you cannot gather on the Capitol steps and dress up in your camo and strap on your AK and hang out with your buddies. We're just telling you that if that's what you want to do, you need to stay 6 feet apart and you need to wear a mask. That's it. But there are even more alternatives, right? The government can say, look, if you want to dress up in your camo and charge up Mount Basement steps with your video cam running, and then post it to some friendly venue, that's another way that you can express precisely the same message. How about you write a letter to the editor and tell the editor of your local newspaper what a lousy person the governor is for trying to save your life? Go ahead, express your message that way. There are any number of alternative ways that you can go about saying precisely the same thing, whatever it is. I'm not sure, quite frankly, what the message is. But whatever it is, there are lots and lots of different ways you can say it without putting your own life and countless other lives in imminent peril.
So I think we're running up against the clock here, but just from there, so it sounds like we're saying, look, time, place, matter, government has a good, and I certainly agree. The government has a decent argument, a very good argument under time, place, matter. And if one more time for old time's sake, right? If you fail the time, place, matter test, that just leaves you with strict scrutiny. And in other words, if it's a content-based restriction, that leaves you with strict scrutiny, and we've sort of beat that horse to death. There's a compelling interest. There's no other way to stop the spread of this disease, right? That's what narrowly tailored means, right? Is that there's no better way to do it, or no, at least no reasonable alternative, right? Other way to do it. So these constitutional arguments that people are running around making, they're certainly not based on Supreme Court precedent. They're not based on legal principles that have developed over the years, and they're not winning arguments. People are running around saying that you're violating the Constitution. They don't know what they're talking about. They don't understand First Amendment law.
Well, even more disconcerting to me, quite frankly, are these lawyers who show up everywhere and say, this kind of regulation is flat out unconstitutional. Well, if you hear a lawyer say that, you can immediately conclude that one of two things is true. Either, number one, that lawyer is lying to you, deliberately attempting to mislead you, or number two, that lawyer somehow managed to miss an entire constitutional law course in law school. This kind of regulation, regulating in the interest of life and health, is the absolute essence of what we have governments for and what we expect governments to do. So to say that this kind of what is, by any rational analysis, narrowly tailored kind of public health, welfare, or safety regulation is unconstitutional is just flat out wrong, period.
Yep. And you're right. I see it on social media as well. Actual people who actually have law licenses, speaking in absolutes, right? Quarantines are unconstitutional, and any regulation of speech is unconstitutional, and it's nonsense. So
I just shake my head and go. I can't even go there.
Right. Well, that's probably a good note to end on. So hopefully this was helpful for people to understand some of the really basic legal principles, content neutrality and strict scrutiny, time, place, matter, and strict scrutiny. Those are the answers to the questions people are asking. So thanks, and we'll be back talking about some other issue here soon.
Thanks, everybody. See you soon.